Okay, this is WMU Political Science 3250, Distance Learning number 9, discussion on the appellate process, as well as a short discussion on writ of habeas corpus. This is our last formal lecture. The next lecture and the final lecture, Distance Learning number 10, will be a review for the final examination. That examination will be on the afternoon of Thursday, April the 23rd. This topic for today, that is from April 13, 2020, the appellate process and habeas corpus review, is not in the book. So you'll need to make sure that you pay attention to these notes. You'll be expected, of course, to understand the concepts that I present in the lecture. The other things that are on the syllabus for that date, civil and criminal liability for law enforcement, other constitutional issues, we're not going to delve into this year. So you do not need to read Chapter 10 for purposes of the final exam. If you're interested in it, it's a good read, talking about civil and criminal liability for those officers who work in law enforcement, but not a requirement for purposes of the examination. Again, appellate process and habeas corpus review. As we talked about from the beginning, the trial level is where the decisions are made in terms of the admissibility of evidence, pretrials, actual receiving of evidence, sentencing. Each state has a main trial level. In Michigan, it's the circuit court. The federal level, they call it the district court. And each state and the federal government has an appellate process. In Michigan, we have 2 levels of appeal. That is the Court of Appeals, and then beyond that is the Supreme Court. Similarly, with the federal jurisdiction, the first appellate level is known as the Circuit Court of Appeals. And for Michigan and Ohio and Tennessee, that includes the Sixth Circuit, which is held in Cincinnati. If you don't like a decision of a federal circuit court, you can then seek appeal to the to the U.S. Supreme Court. When it comes to decisions at the trial level, whether it's federal or state trial level, every defendant has the automatic right to appeal to the appellate court. So if you don't like the decision Judge Bridenstine imposed in terms of suppressing a piece of evidence or not suppressing it, his decisions regarding bond, his decisions regarding sentencing, how the trial was conducted, everyone has the automatic right to appeal the conviction and the circumstances surrounding the conviction to the Court of Appeals. As I mentioned, the Michigan Court of Appeals is a 3-member body. I mean, there's a total of about 24 or 25 Court of Appeals judges. They meet as 3-member tribunals because 2 out of the 3 need to make a decision as to what should happen to the case. Similarly, in the federal system, the district court makes decisions at the trial level, and every defendant has an automatic right to appeal to the Circuit Court of Appeals, where it's a 3-member group that decides on the issue before the Court of Appeals. The appeal process is not an evidentiary hearing. Only the procedures are followed. What I mean by that is that all evidence is received, and those decisions based on the evidence are received at the trial level. At the appellate level, the court makes a decision based on the transcript, that which was heard at the trial level, and the law. What happens is an attorney for each side walks into the appellate courtroom, makes an argument to the 3-member appellate judges, and then the 3-member appellate judges render a decision. And it's based on the legal argument and the transcript of what took place at the trial level. The decisions of the Court of Appeals are 3 in number. That is, there's 3 broad things that they can do. The first of which is they can affirm the decision of the trial court. They can also reverse the decision of the trial court. And the third decision is to reverse and remand, or remand, simply remand to the trial level. So affirm, reverse, and remand. Those are the 3 broad options that the appellate court has the right to conduct. The same is true at the Supreme Court level. They can affirm, they can reverse, and they can remand. Again, the process is the trial level makes all these decisions based on the evidence received at the trial level. whatever decision is made, automatic right to appeal to the first level, that is the Court of Appeals, and then, if possible, they can appeal to the Supreme Court for each jurisdiction. In order to get to the Supreme Court, that is, if you don't like the decision of the Court of Appeals, you need to ask permission of the Supreme Court to hear the case. That is, you don't have an automatic right to get to the Supreme Court. You have to ask for permission. That's why the Supreme Court of Michigan, Supreme Court of Ohio, the federal Supreme Court have many fewer cases, because they pick and choose those cases that either have a major policy implication or are significant such that they want to get their teeth into it. Otherwise, they leave it up to the Court of Appeals in each jurisdiction to make the decision. What is affirming the decision? Affirming simply means that whatever the trial court did was not inappropriate. They don't necessarily have to agree that it was a good decision. It was just not inappropriate. We're affirming whatever it is that the trial court did. If the trial court decided to sentence somebody to 10 years in prison and the defendant argued that that was an Eighth Amendment violation, cruel and unusual punishment, and he appealed to the Court of Appeals, the Court of Appeals may say, based on the law and all the material provided to the trial judge, that the decision was not inappropriate. That's called an affirming of the decision, affirmation of the trial court decision. Another option is to reverse the decision. That is, if the trial court did something wrong. If they allowed a piece of evidence at trial they should not have allowed, then the appellate court may reverse the decision and tell the trial court, you're not allowed to use that evidence at trial. Maybe the trial court sentenced somebody to 10 years in prison and the Court of Appeals reversed it, saying it was inappropriate. That is, we're not allowing the person to be sentenced to 10 years in prison. So that's the second option, that is to reverse the decision, and that is telling the trial court you've committed some type of error and we are changing it. The third option is to remand. And remand comes in generally two forms. Maybe the trial court made a decision and there's not enough on the record to support why the decision was made. The Court of Appeals may remand the case back to the trial court to further explain why the decision was made. That's when it doesn't appear based on the transcript that there's enough information for which the trial court should have made that decision. Sometimes the appellate court does a reverse and remand. For example, if they say to the trial court, you should not allow a piece of evidence in trial. So we're reversing your decision, Judge Bridenstine, and we're remanding it, sending it back to you so you can now proceed with the clarity of the Court of Appeals decision. So we're reversing your input, your decision, and remanding it, sending it back to you to either conclude the trial or to move forward with the proceedings. That's called a remand. Again, affirming, reversing, remanding are the three options that the appellate court may do. And as I mentioned, that also applies to the Supreme Court for each jurisdiction. Affirming, reversing, or remanding. Now, let's talk a little bit about the concept of writ of habeas corpus. What does that mean? As you recall in reading these cases, most of them occurred in state court. That is, California versus Greenwood was a case that involved a state court matter. Arizona versus Youngblood, that was a state court of Arizona matter. Rhode Island versus Innis was a state court case in Rhode Island. The question becomes, how does a state court case make its way to the United States Supreme Court? And that is through this concept that we call the writ of habeas corpus. What happens is that we'll use California versus Greenwood as an example. As you recall, in that case, the state of California law enforcement officer got some garbage provided to them by an agent of the government, that is the garbage collector at the direction of the law enforcement officer, received the garbage from the guy's container out in his yard, brought it to the police station. The police went through it. They got information that led them to believe that Mr. Greenwood was conducting some kind of drug operation in his home. He ultimately is convicted at trial, in part because of the evidence of finding the drug paraphernalia in his garbage. He didn't like the decision of the trial court, so he appealed that decision to the California Court of Appeals. If he didn't like the decision of the California Court of Appeals, which in this case he didn't, he appealed the decision to the California Supreme Court. Ultimately, the case did not end at the California Supreme Court. Why? Because we know the decision is from the United States Supreme Court. So how do you get from the silo that is the California courts, when one would think that the California Supreme Court has the final say in the matter? How do you get from there to a U.S. Supreme Court decision? And what happens is that's the writ of habeas corpus. What happens is that an individual who is not satisfied that the state in which he is or she is facing prosecution has handled the case appropriately, that individual can ask the federal court to take the case. And they do so by a writ of habeas corpus. They ask the federal court to issue the writ of habeas corpus, which means an order, as we talked about. Writ means an order. Habeas corpus is Latin for you have the body. It's an order to the state court to bring the body, that is the case of an individual, to the federal court. Then it makes its way to the United States Supreme Court. That's how you have these state court cases getting to federal court. Normally, a state court case will just stay in state court. And the Michigan Supreme Court, California Supreme Court, Rhode Island Supreme Court would be the final say. However, there is this mechanism to get the federal court involved. And the reason why it is because we want to make sure that the federal court has an opportunity to get the baseline constitutional requirement for everybody, no matter what state they live in. So when we have California versus Greenwood make its way up to the California Supreme Court, if it ended there, then the rule that California had may not apply to Nevada or may not apply to New Mexico or to Florida. When you get the case to make its way to the United States Supreme Court and they render a decision, now that's the bare minimum that must be federal requirement for the citizens when we're talking about constitutional issues that apply across the country. If we did not have this mechanism, that is the writ of habeas corpus, then the state of Alabama, in Powell versus Alabama, might continue to provide, not give court-appointed lawyers to criminal defendants. They made a decision that you don't get a court-appointed lawyer. The individual appealed to the U.S. Supreme Court and said, no, when you meet this criteria, you do get a court-appointed lawyer. So this is how you take state court matters and turn them into federal matters when it comes to the minimum federal requirement under the Constitution. And the way in which this happens is to get into federal court, and the way you get into federal court is through this writ of habeas corpus. If you didn't have this mechanism, you wouldn't have the federal court being able to express the opinion about what every state should have as a bare minimum. Now, if it's a federal crime that is committed, then you just go up the federal court system. You don't make your way into the state court system. There'd be no purpose in doing so. So if you commit a federal crime in Michigan, you want to appeal it to the Circuit Court of Appeals in Cincinnati, and you don't like the decision, and you seek appeal to the U.S. Supreme Court, that's the end. You don't get another avenue. When the courts, the U.S. Supreme Court speaks, that's it. There's no appeal beyond what the United States Supreme Court has done. Now, when you do a writ of habeas corpus, the purpose is not to relitigate, that is to try the state court cases. It's simply to determine whether or not the state court committed any error in its decision. And again, the decisions are either to affirm, to reverse, or to remand. The only way in which you can actually seek federal habeas corpus review, if you're in a state court matter, is to exhaust all of your state court remedy. If you were in state trial court, if you came in front of Judge Bridenstine and you had a trial and Judge Bridenstine admitted evidence that you didn't think was appropriate and you were ultimately found guilty and he sentenced you to prison, and if you didn't like the decisions of Judge Bridenstine, you don't immediately get to go to the federal United States Supreme Court. You have to pursue your right to appeal in state court first. So you have to go to the Court of Appeals And if you don't like the decision there, you have to seek review by the Michigan Supreme Court. And if you don't like the decision there, you have now exhausted all of your state court remedy. There's no other options for you. There's nowhere else for you to go in state court. Once you do that, when you exhaust all of your state court remedy, then you can seek relief in the federal court. They don't have to take your case. It's entirely up to the federal court to decide whether or not to take your case. But you don't get to simply jump from Bridenstine's state courtroom right into the federal system. Now, if you appeal to the Michigan Court of Appeals and they affirm Bridenstine's decision, and you ask the Michigan Supreme Court to handle the case, and they say, no, we don't think that it's a good enough case for us to handle. Have you exhausted your state court remedy? And the answer is, yes, you have. You have done all that you can in order to get a resolution in your favor. You can't go to the Michigan Supreme Court because they won't take your case. So after the decision of the Court of Appeals, you can seek habeas corpus review because you have exhausted all of your state court remedies. But you have to at least attempt to get your state court relief before you get federal court relief. That's the limited information I'd like you to know about writ of habeas corpus. Combine that with the appellate process that I just talked about. We'll wrap up that which is important for you to understand for the final exam next week. Again, this is distance learning number 9, appellate process and habeas corpus review, and we'll call it at that at about 16 and a half minutes.